Hello friends, in the series on the income tax cases, today we will discuss a very important case on the miscellaneous applications filed by the revenue. In those cases where the tribunals have given the relief to the assessee before the Supreme Court judgment in the case of Checkmate Services Private Limited versus Commissioner of Income Tax, which was given on 12th October 2022. In the present case, the issue before the Honorable Bombay High Court was that whether the tribunal is justified in allowing the miscellaneous application of the revenue for those cases in which the tribunal has allowed the appeal of the assessee in the case of ESI and PF matters before the Supreme Court judgment 12th October 2022 in allowing the miscellaneous application of the revenue. This issue has been taken up by Honorable Bombay High Court in the case of Infantry Security and Services versus Income Tax Officer, and this case is reported in 474 ITR at page number 584. The date of the judgment is 3rd December 2024. In the present case, the case of the assessee is related to the assessment year 17, 18, 18, 19 and 19, 20. And the assessing officer has disallowed the share of employees for Provident Fund and ESI under section 36 subsection 1 clause 5A on the ground that they has not been deposited before the due date in the respective acts, although they were deposited before due date of filing the return of income under section 139 subsection 1. The CIT appeal has given partial relief. The tribunal has allowed the appeal of the assessee in full. The tribunal allowed the appeal of the assessee on 26th July 2022. After allowing this appeal, on 12th October 2022, the Honorable Supreme Court in the case of Checkmate Services Private Limited versus Commissioner of Income Tax, which is reported in 448 ITR at page number 518 and which is decided on 12th October 2022, the Honorable Court said that the disallowance under section 36 subsection 1 clause 5A is justified when the share of Provident Fund and ESI relating to the employee share is not deposited within the time limit given in the respective acts, even if they have been deposited before the due date of filing the return of income. Meaning thereby the decision came in favor of the revenue. The revenue, by taking the base of this judgment, filed numerous miscellaneous applications throughout the country in the respective tribunals by taking the plea that this is a mistake apparent from record as per section 254 subsection 2. And when in the present case this miscellaneous application was filed by the revenue, the tribunal allowed the miscellaneous application of the revenue and reversed its earlier judgment given on 26th July 2022. The assessee filed the writ petition in the Bombay High Court on the ground that the miscellaneous application cannot be filed in the present case because the Supreme Court judgment has come after the passing of the tribunal judgment. So it cannot be said that there is a mistake apparent from record. According to the assessee, only in those cases where the tribunal has passed the order by ignoring a judgment of the jurisdictional high court or a Supreme Court judgment as on the date of the judgment of the tribunal can be termed as erroneous under section 254 subsection 2, or it can be said that as mistake apparent from record. But on the basis of a judgment which has been given after the judgment of the tribunal, it cannot be said that it is a mistake apparent from record. When the Bombay High Court heard the matter, the court said that in the present case, the assessee succeeded before the tribunal as per the law as on that date. Supreme Court judgment never existed on the date when the tribunal gave its judgment, and there is no mistake apparent from record as per section 254 subsection 2 because the Supreme Court judgment came after the judgment of the tribunal. That judgment was not available on the date when the tribunal gave its original judgment. In the present case, the court said that the tribunal erroneously invoked the jurisdiction under section 254 subsection 2 on the ground that the revenue has filed the miscellaneous application 92 days after the due date of filing the miscellaneous application. So on both grounds, the Bombay High Court allowed the appeal of the writ petition of the assessee. The court also said that the jurisdiction of tribunal under section 254 subsection 2 is akin to the review jurisdiction of the civil court under the provisions of 47 Rule 1 of the Civil Procedure Code of 1908 to rectify any mistake apparent on the face of record, and such jurisdiction on the tribunal is more restricted. So in the nutshell, the Bombay High Court allowed the appeal of the assessee, and the relief which was given by the tribunal in its order and which was reversed by the tribunal through the miscellaneous application of the revenue was quashed by the Bombay High Court. At the end of this video, once again I am repeating the name of the case. The name of the case is Infantry Security and Services versus Income Tax Officer, and this case is reported in 474 ITR at page number 584, and the date of the judgment is 3rd December 2024. Thank you, friends.